Okay, Judge, Miss Thompson is ready on Harley Cox.
All right, court call CR 2155, State versus Harley Cox. Set for arraignment today.
Yes, Your Honor, we have gotten a copy of the indictment. I've gone over it with Mr. Cox. He does understand what he's charged with, Your Honor, and for purposes of today's hearing, we plead not guilty, waive the reading of any formal indictment.
All right, the court will find that Mr. Cox has been arraigned, that he enters a plea of not guilty into the record. Court will set pretrial in this matter on May 27th at 1:30 if he's in jail, 9 a.m. if he's on bail.
Yes, Your Honor, thank you.
You're welcome.
And Ms. Beasley's ready on Austin Walker.
Court calls CR 2200 and 232, State versus Austin Lynn Walker, set for docket call today. Ms. Beasley, go ahead.
Yes, Your Honor. It's my understanding that the DA wants to resolve this after the co-defendant Courtney Odom's case is taken care of, and I believe I've checked with Ms. Taberham, and Ms. Odom's case is reset for May 11th. I'd ask that this case be set on May 13th.
I believe we have a criminal setting on May 13th. I can set it for the 25th or the 27th. I think I set you previously this morning on one of those.
Yes, sir. On the 27th, that'll be fine with me.
All right, court sets Mr. Walker then for docket call on May 27th.
Thank you, Your Honor.
You're welcome.
Now we're ready on Anthony Clifton.
All right, court calls CR 17357, State versus Anthony Wayne Clifton. All right, I believe that we're set on a motion to revoke today. Go ahead, Ms. Beasley.
Yes, Your Honor. I just got appointed this morning to Mr. Clifton's case. I understand he's on the docket today for a motion to revoke his probation. However, my appointment includes 8 other cases everywhere from an aggravated assault, first-degree felony offense down to a Class B misdemeanor. Total of 9 cases, I think, are pending against him. And I'd ask the court to reset this in order that I can get the discovery and start working on his case.
Okay, court will reset this motion to adjudicate. I don't know that we have settings on the other cases yet. Probably not. So I'm going to set this out a little bit further. I'm going to set it out on to June 3rd. Do you have any conflicts on that date?
Check, Judge. I do not, Judge. That's good. That will work.
All right, we'll set Mr. Clifton then June 3rd for another hearing on his motion to revoke, and we'll see what happens with the other charges.
Judge, since he's has so many cases pending, can we just put it as a setting? Obviously, his motion to revoke may be resolved with the other cases. I don't want to necessarily get prepared for a motion to revoke if we've got all these other cases that we need to deal with.
Yeah, what was your request?
Is that we just set it for a setting, pretrial setting, whatever the court wants to do. I'm just asking that it not be set for a contested motion to revoke hearing.
Yes, it's not set for a contested hearing.
Okay.
So 6-3 is not a contested date.
Thank you, Your Honor.
You're welcome.
I'm sorry. Your Honor, I believe Michael Mason Jr. is also on the docket. He's a client that's being held in the Gregg County Jail.
Okay. CR 25-6. Go ahead.
I spoke with his defense attorney, Mr. Parrish. They do now have an offer in the case. He's got to convey that to our client, and then he'll let me know. So I'm asking for additional setting because they have not resolved their cases in Gregg County, but he thinks they should be able to do that same.
Do you know what the offer is in Gregg County?
Prison time, I think it's 6 years prison time.
Okay. Let's set Mr. Mason on that same June 3rd date,
Yes, sir. I appreciate it.
custody status.
May I be excused, Your Honor?
Yes, ma'am. Thank you.
Thank you, sir.
All right, it'll be just a minute. We've gone to get some others.
Yes, ma'am.
I forgot one thing.
Yes, ma'am.
Do you have the judgment on Gomez?
Yes, ma'am, I do.
Okay, well, we don't have a copy out here to have him fingerprinted. I called Tyler before lunch and I was gonna pick it up, but then they've just now emailed us and told us that you had it.
Okay, I'll send a copy out there.
Okay, thank you.
Who do you want me to send it to?
Karen or myself, either one.
To your email?
Yes, sir. I brought a laptop.
Okay, all right.
Mr. Schmidt is ready with Mr. Hill.
Ms. Abraham,
Yes, sir.
did you see my text message? I am missing. Okay. Do you have that there with you?
I don't have anything. I'm fixing to ask Tyler
Yeah, because it's missing, I think, the first 2 pages of the defendant's waiver.
because Kurt Noel was going to appear by Zoom.
Yeah, so I'm gonna need that before we can do that plea.
Can we tell Tyler?
Tyler doesn't know anything, I guarantee you.
Mr.
Let me
White?
look into it and we'll get it fixed.
Okay, thank
Yeah, I'm missing, I don't have the first 2 pages of the defendant's waiver of rights and plea of truth. I've only got
Okay,
a signature page and I've got my signature page. I do have the judgment and I've got the evidence that attaches to it, but I don't have the admonishments on the first page. It came to me. like that.
yeah, we'll get that fixed, Judge, and sent over.
Okay. All right, court calls CR 2120 and CR 2174, State versus Michael Jerome Hill, set for pretrial in the CR 2120 case and set for arraignment in CR 2174. Let's take up the arraignment first, Mr. Schmidt.
Yes, sir, Judge. I've talked to Mr. Hill about the indictment. We've looked at it. His name is spelled correctly. He understands what he's been charged with. At this point, we wait for the reading of that indictment, enter a plea of not guilty. Ask the matter to be set for pretrial. Judge, in addition, on the CR 2120, they're the same transaction offenses. We're asking that we get an additional pretrial for that and carry them both to pretrial on that May 25th date.
Okay, court will set each case for pretrial on May 25th at 1:30 if Mr. Hill is in jail, at 9 a.m. if he is on bail.
That's all we have, Judge. Can I be excused?
Yes, thank you, Mr. Schmidt.
Mr. Sanders is ready on 8.
Court calls CR 2385, Cody Eden. Set for docket call today, Mr. Sanders?
Yes, Your Honor. And Judge, I was asking if we could reset it one last time, do one more docket call and see if we can get something resolved with the state.
What's the status of the negotiations at this point that would need a resetting?
Well, Judge, we have an offer. I'm still talking with Mr. Eden about that and about the facts of the case. I believe we had a little bit more time. We might be able to reach a resolution in the matter in talking with him and the state.
What's the offer in the case right now?
It's 20 years TDC and $1,000 fine.
20 years TDC
Yes.
and a $1,000 fine?
Yes.
Any objection from the state?
No, Your Honor. I reached out to Mr. Sanders yesterday. We've been in communication. I do believe a little bit more time and hopefully we can reach a resolution.
How much time do you think is appropriate, Mr. Sanders?
Judge, if we could set for the end of May, May 27th. I know I had a couple of resets for that date this morning.
All right, court will set for a final docket call on May 27th So on that, Sanders, there will either be a plea agreement between Mr. Eden and the state, or we'll place him on our jury selection docket.
Thank you, Judge.
Mr. Campbell.
Campbell?
Yes, sir.
All right. Court call CR 2110, State versus Charles Campbell. This is a motion for bond reduction.
Yes, sir. And we're also here on pretrial, which we don't have any pretrial issues as to the case itself.
Court will then set this for a docket call on May 27th. And we'll take up the motion for bond reduction.
And Judge, I would call Mr. Campbell just for the limited purposes of this bond hearing.
Mr. Campbell, if you'll raise your right hand, I'm gonna place you on. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, make sure you speak up loudly and clearly.
I was trying to.
I'd ask that everybody in the jail court, please be quiet. We're having some difficulty hearing in the courtroom. Go ahead, Mr. Sanders.
Thank you, Judge. Mr. Campbell, you're currently incarcerated in Van Zandt County Jail on $500,000 bond, is that correct?
Correct.
Okay. And you were arrested September 22nd of 2020, is that correct?
Yes.
And I believe you were indicted about January 20th of 2021, is that correct?
Yes.
And so that was from the date you were incarcerated to the date of the indictment was more than 90 days, is that correct?
Yes.
Okay. And because of that, you're asking the court today to grant you a PR bond, is that correct?
Yes.
Okay. And if the court won't do that, you're asking for at least a bond reduction, is that right?
Yes, sir.
Okay. Now, as far as that amount is concerned, do you, and your ability to pay anything to bond out, do you have any kind of cash resources, savings account, checking account, anything like that that you can put towards bonding out of jail?
I have nothing.
Okay. And I know I've been in touch with some of your family. Do you know approximately how much money they might have that they could put towards bonding you out of jail?
Maybe 4,000 at that.
Okay.
So I can't hear you, Mr. Campbell. Say again.
About 4,000.
And so if the bond was reduced to maybe 50,000 or 40,000 at 10%, they would probably be able to bond you out at that point. Is that fair to say?
Yes.
Okay. And do you understand that the judge grants a PR bond or reduces the bond to an amount you can bond out at, that there would be certain conditions he would require you to comply with? Okay. And probably one of those would be to have some kind of GPS monitor that you would have to have attached to your ankle so that basically you're monitored wherever you're going.
Right.
Okay. Is that something you're willing to do?
Yes.
And any other conditions the court would set, you're willing to comply with those rules as well?
Yes.
Right? Which would, in addition, could include not having any kind of contact, any kind of communication with the alleged victim in the case.
Correct.
Okay. We passed the witness, Your Honor.
State, any questions?
Yes, Your Honor. Mr. Campbell, do you own a car?
No.
How would you get from place to place if you were to bond out?
My mother.
Your mom? Okay. And is that who you would be living?
Yes.
Oh,
Ms. Heisel, we've lost you.
I'm sorry, Judge. My system froze. Mr. Campbell, can you repeat that?
Yes. And that's where we go. Yes.
Okay. And does she reside here in Van Zandt County?
Yes.
Are you aware that an ankle monitor has costs associated with it. Have you had that conversation with Mr. Sanders?
No, but I understand there's like a $300 a month limit or fee or something of that nature.
And do you believe that if that was ordered by the court, that you or somebody in your family could come up with the money to properly maintain that?
Yes.
Mr. Campbell, are you aware of the state's offer in this case?
No.
Okay. So no plea offer has been communicated to you at this point?
No.
Judge, I'd pass the witness.
Mr. Sanders, any additional questions?
No other questions, Your Honor.
Ms. Heisel, any evidence for the state?
Yes, Your Honor, at this time, and for the limited purposes of this hearing, we'd offer proposed State's Exhibit 1, which has been tendered to the court and to defense counsel.
Mr. Sanders, any objection to State's Exhibit 1 for the purposes of this hearing?
No objection.
All right, State's Exhibit 1 is admitted for the purposes of the motion for bond reduction. Go ahead, Ms. Heisel.
Your Honor, we would just ask you to review that prior to making any decision in this, and we would rest reserving for argument.
Okay, and let me ask some clarifying questions if I can. So when was Mr. Campbell arrested?
It was September the 24th, Your Honor.
And when was he indicted?
Exactly. I believe it was returned January 30th. But if Mr. Sanders can get to it before I can, feel free to correct me if that's wrong.
Judge, it was sometime in January. The file mark is covered up by some of the print on the page. So sometime in January 20th through 29th.
Is there so there's an agreement that it was outside of 90 days?
Yes, Your Honor. The Van Zandt County Sheriff's Office did not bring us a case until pretty much right at the 90-day mark. In fact, I believe it might have been slightly after, and we returned an indictment at the very next grand jury date available, but it was outside of that 90 days.
Okay. All right, Mr. Sanders, would you like argument?
Judge, we believe that because it was outside the 90-day period, that Mr. Campbell's entitled to a bond reduction. We're asking for a PR bond. He doesn't have the funds to bond out, and probably at the most from his testimony, if the court doesn't grant a PR bond, we'd ask that the court lower bond to $40,000 to $50,000. I believe that's at least a range when where his family would be able to bond him out that amount. But our obviously our first preference will be for a PR bond because he himself doesn't have any kind of assets that he can use to bond out of jail.
Thank you, Mr. Sanders. Ms. Heisel?
Your Honor, you have the affidavit of probable cause before you, and you can see the serious nature of these charges. And because of that, we would ask you not to grant a PR bond. Additionally, we would ask you, we understand that the law says that a bond reduction of some sort is required by law, but we would ask you to leave that at the highest amount possible that the court finds is in compliance with the law. In addition, we would ask for no contact conditions with the victim. We would ask for geographic restrictions around the victim's schools and homes. Your Honor, we would ask for GPS monitors. We do believe that Mr. Campbell has the potential to be a flight risk. As you can see in the affidavit of probable cause, Mr. Campbell has already confessed to several different acts of sexual assault against his oldest daughter. And because of that confession, Your Honor, we just don't want him to get cold feet about the reality of his situation and take off on us. We would ask for a GPS monitor. Also, the GPS monitor would help us monitor the no contact conditions. So we understand that the law would require some kind of reduction, but we would ask that it be the highest that the court believes is possible under the law and with those conditions.
Thank you, Ms. Heisel. Mr. Sanders, anything else?
Other than just as far as the amount goes, I think it's something where the reduction would have to be to a point that if it's not a PR bond, at least it's an amount that the defendant could make. I think from the testimony, $40,000 to $50,000 bond would be the appropriate amount if the court doesn't see fit to grant the PR bond.
All right, thank you, Mr. Sanders. All right, the court's going to take the matter under advisement. I will review State's Exhibit 1 and will issue a written order at the conclusion of today's docket. And I'll provide that to both you, Mr. Sanders, and you, Ms. Heisel, by email.
Thank you, Judge.
And Ms. Thompson is ready on Angela Basham.
All right, court star 15447, State versus Angelina Basham, set for motion to revoke. Go ahead, Ms. Thompson.
Your Honor, we're gonna ask the court to give us a little more time to reset this. Ms. Basham and I have been trying to communicate, but I believe she may have been calling my old office number. I wrote her a letter. Bottom line is we haven't been able to get together on this. I believe that we will be able to resolve this. She thinks that we will be able to resolve it if we get just one more setting on this.
I think I made out most of that. I don't know if Ms. Grisham did. Let me repeat what I heard. I think you said that you and she have not had a chance to get together to discuss the case, that you're asking for more time, that you believe that you'll be able to get it resolved.
Yes, Your Honor. I believe she was given my old office number, and that was what she was calling. And we hadn't been able to communicate. I had been writing to her, but just missed each other.
Do you think 2 weeks would be enough time?
Yeah, 2 weeks. Should be. Yeah, she thinks so, Your Honor.
Okay, what I'll do is I'll set this for the contested docket on April 29th. That'll be at 9 a.m. that day, 9 a.m.
Yes, sir. All right. Thank you, Your Honor. That's all I have, ma'am. Excuse?
Yes, ma'am. Thank you, Ms. Thompson.
Yes, sir.
Deputy Case.
Okay, it'll be a few minutes. We're gonna go get.
Yes, Your Honor. As you were.
How are you doing, sir?
Doing great. Stella says hello.
Hello, Estella.
Get Mr. Crocker.
All right. Mr. Crocker's up next. It'll be a minute.
Yes, sir.
Okay.
Judge Martin?
Yes, ma'am.
If they're ready on Mr. Crocker.
All right, court call CR 19-229, CR 2240, CR 2241, State versus Evan Ray Crocker. Show that we're set for docket call.
Yes, sir. State, my uncle Jeff White and I have been in conversations regarding the possible resolution of this matter. I think we've made some significant movement in the last week or so. I think if we had a little more time, and I think the state would be on board with this, I think that there's a possibility of a resolution without a trial on this.
State.
Judge, that's correct. I communicated a new offer yesterday. Mr. Nolan White and I had talked about some different possibilities last week, but I formally communicated a new offer to Mr. Jeff White, I believe this morning. Intended for it to be yesterday, but I think it ended up being this morning. So we wouldn't be opposed to one more reset.
Okay. I show that one of his cases is a motion to revoke, and the other two are newer cases.
That's correct, Your Honor. And the current offer would resolve the motion to revoke in one of the new cases with a dismissal of the other.
And if Mr. Crocker does not accept that, then you'll move forward with a motion to revoke.
Yes, Your Honor.
What I would propose is we set this in 2 weeks on April 29th on the contested date. And that way, if Mr. Crocker doesn't accept or the state doesn't accept any counters, then we'll just move forward on the motion to revoke and finish up with that case, resolve that case one way or the other. And then we would move on to the other two pending cases. Obviously, that's my perspective on that is if there is no resolution, but how do y'all feel about that?
Well, I would prefer for us to reset it for 30 days so we can, so we're not so time crunched in case we need to work through some other things.
My only concern about that is our jail's at max capacity, and the more I let people have 30-day resets, the further it puts us behind.
Well, I would point out to the court, I don't think resolving it 2 weeks earlier is going to clear it out quicker because we still got to have some other cases that are pending.
No, that's true, but it creates a backlog on our bus tickets to TDC though, because it might still be 30 days or more before he goes, if he goes to TDC. Ms. Heisel?
Judge, the only thing I would say is this is a 4-count motion to adjudicate, and counts 1 and counts 2 are the new offenses which are indicted and on the court's docket. So ultimately, to prove up the NTA, the state would more or less have to prove up the 2 other offenses, which I think that would basically result in us going to trial on the 29th on those 2 other causes. All of our witnesses, subject to availability, we can get them here, Your Honor. I just, that might be a tricky turnaround for the state if we were going to proceed on counts 1 and counts 2.
So Mr. White, you're asking for May 25th?
I'm asking for May 25th. Yes, sir.
All right, I'll defer and set this for docket call on May 25th, but it'll have to be the final docket call. So if there's no agreement reached that day, I'll set the MTR for a contested hearing, and we'll just place the other ones on the jury selection docket.
We'll note that and we'll be ready to go one way or the other, Your Honor.
Thank you, sir.
Judge, is there a reason you've muted my video?
I don't think you can mute a video, but yeah.
It says the host has stopped my video.
Yeah, I was tired of looking at your chair, if you want me to be honest.
That's fine. I mean, I'm here, Judge. I can't turn my video back on.
You can't turn it back on? Wow, I wish I would have known that a lot sooner.
Do you have Mr. Noel on Zoom?
I do, yes.
We have Mr. Gomez if we have his plea paperwork.
Look at that, the state is back. Yes, I do. Okay, go ahead and bring Mr. Gomez up. I'll bring Mr. Noel in.
Did you get the papers that you were needing?
Yeah, yes, I believe so. I'll be with you in just one moment. All right, the court call CR 15-456, State of Texas versus Stephen Ray Gomez. Mr. Gomez, if you'll raise your right hand, I'm going to place you under oath, sir. Sir, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God? Say it again, I can't hear you.
Yes, sir.
Okay, make sure you put your hand down. Make sure you speak up loudly and clearly so my court reporter can hear you. All right, Mr. Gomez. You appeared before the court on July 14th, 2016 on the offense of criminal mischief, state jail felony. Court heard the evidence on that day, found that there was sufficient evidence to convict you. However, the court deferred a finding of guilt and placed you on community supervision for 3 years and assessed a $1,000 fine. It was during your community supervision period that the state filed a motion to adjudicate and revoke, and they alleged 7 different counts alleging different ways of violation of your community supervision conditions. Have you had an opportunity to review that with your attorney, Mr. Kurt Knoll?
Yes, I have.
Do you feel like you've had enough time to talk with him about that, have all your legal questions answered?
Yes.
Are you pleased with Mr. Knoll's representation of you?
Yes, I am.
Mr. Knoll, do you believe Mr. Gomez to be competent today?
I believe so, Your Honor.
And does your client waive the formal reading of the state's motion to adjudicate?
We would, Your Honor. We have reviewed that.
And is it his intent to plead true to all 7 counts as alleged?
It is, Your Honor.
Okay. All right, Mr. Gomez, then I'm going to ask you at this time, how do you plead to counts 1, 2, 3, 4, 5, 6, and 7 as alleged in the state's motion to adjudicate? Are those counts true or not true?
True, sir.
And are you telling me that those are true because those are true and for no other reason?
Yes, sir.
And has anyone threatened you or forced you or pressured you to make you feel like you had to plead true to any of these counts?
No, sir.
All right, the court will accept the defendant's plea of true to each count as alleged in the motion. Mr. Knoll, any objection to the admission of the defendant's waiver of rights and plea of true as states Exhibit A?
No, Your Honor.
All right, states Exhibit A is admitted into evidence. The court will take judicial notice of Mr. Gomez's judicial confession. Anything further from the state?
Judge, I would just note for the record that Mr. Gomez has paid in full his financial obligations to Van Zandt County, including the fines, fees, and probation costs accrued to this time. He paid those in advance of today.
Good. Thank you for that, Mr. Woodwhite. I'm glad to hear that, Mr. Gomez. Mr. Gomez, another question. Your signature as it appears on these documents, would you tell me that that is your true and correct signature?
Yes, that is.
And you've only signed that once you've only signed that certifying that you understood what you were signing, correct?
Yes, sir.
Okay. I'll look at your paperwork real quick. Right, based on the evidence presented to the court finds that you have violated the terms and conditions of your community supervision. The court will follow the plea agreement. In this case, the court hereby adjudicates your guilt for the offense of criminal mischief greater than or equal to $1,500, but less than $20,000. The court revokes your community supervision, assesses your punishment under section 1244A of the Texas Penal Code, assesses your punishment at 79 days confinement in the Van Zandt County Jail. The court will issue you 79 days credit for time served on that cause. The court will find that you are ordered to pay the balance of your financial obligations, and the court accepts Mr. Woodwick's statement and certification that you have paid those. And if you've paid everything off, then Mr. Gomez, then you'll be free and won't have any other obligations upon being released from the Van Zandt County Jail. So at this time, I'm going to remand you to the custody of the Van Zandt County Sheriff's Office so he can carry out the terms and conditions of your sentence. I'm going to have you step over with the bailiff to be fingerprinted. Good luck to you, sir.
Thank you.
It'll be just a moment.
Okay.
Are y'all done?
Okay, Miss Judge Martin,
Yes,
we
ma'am.
had Dawn Davis for Mr. Knoll.
You got 3 coming with you.
CR 2112, State versus Dawn Lee Davis, set for pretrial. Mr. Knoll, go ahead.
Judge, I have filed a pretrial motion. I don't know if the state's had a chance to look at it. To be honest with the court, I initially sent some information to Ms. Heisel. Actually turned out that Mr. Woodwick was handling the case now. This was a Daniel Cox case. There's also a potential FTA several months back, which would actually carry the same potential range of punishment as this charge. I have talked to Mr. Woodwick about a possible resolution. He sent me yesterday a plea offer that I need to discuss with my client. I haven't had the opportunity to do that. We're a little more limited now than we were before on jail visits. I was actually over in your county about 7:40 this morning to deliver funds on the previous case. I don't think I'd need more than a couple of weeks reset, and between now and then Mr. Woodwick, or actually probably my client, can decide if she wishes to accept the offer. And then if not, I need to discuss, and I think it would be better discussed between Mr. Woodwick and I, at least initially, on the discovery issue. It involves an issue with a co-defendant.
Yes, I've reviewed the motion. Mr. Woodwick, I see that Mr. Knoll filed this about 3 days ago. Have you had a chance to see or review that?
Judge, I am unaware of what we're talking about. I haven't seen any motions regarding this case. They may have gone to the DAE file and not yet been made it across my desk.
All right, Mr. Knoll has filed a motion for additional discovery, wanting disclosure of any agreement between the state and the co-defendant. And I believe that would be covered by the court's standing discovery order on the criminal cases.
I believe it would, Judge, and I have no issue discussing with Mr. Knoll, obviously not on Zoom, the details of that case and its resolution. I don't know if there's any written documents that I can turn over to him, but I'd be happy to open my file to him to allow him to access the other case and see if there's any information that he feels is necessary for the prosecution of this case.
All right.
And Judge, I didn't find out about the issue involving the co-defendant until I spoke with Miss Davis sometime within the last week. It may have been this week. I don't know. I've been on too many of these lately. I think I've got 18 this week so far. At any rate, I think the case is still resolvable one way or the other, potentially without a trial because of the possibility of another 2 to 10 range of punishment case popping up.
All right, the court's going to find that the discovery motion filed by the defense is covered by the court's standing discovery order in criminal cases. So the court's going to deem that granted. Court will find that there are no other contested pretrial matters raised by motion 7 days prior to today's hearing. Court will set this for a docket call. Mr. Knoll, are you available on 5/27, May 27th?
If the court could actually set it sooner, I think I would know a resolution sooner, and that potentially would mean my client not necessarily sitting in Van Zandt County Jail, but elsewhere. Would it be, I don't know what the court schedule is the rest of the afternoon. Would it be possible to go into a breakout room and I could explain?
Yes, I can set it on April 29th. That's 2 weeks, and that's our contested evidentiary day. I'm fine with that.
Okay, well,
That's the
yeah,
next
that'd
one
be good. I actually have to zooming in Gregg County in the morning. Tomorrow, I mean, the 29th is fine.
Are you available in the morning, or should we set that in the afternoon?
The morning is Gregg County so far, so we should set it in the afternoon. I think would be better. And then if I can get a Zoom with Miss Davis here, if the court has time to do that.
We'll have to see if she's the last one on the docket. I will. If not,
I show a Jonathan Spencer for arraignment, Judge, but that's the only one that I have left.
yes. If you'll stay, Mr. Knoll, then once we finalize the docket, because I can't put you into a breakout room until everyone's resolved.
I understand. I'll stand by.
Okay. So we're
Thank you, Judge.
we're setting Miss Davis for April 29th at 1:30.
Thank you.
You're welcome.
Okay, and Jonathan Spencer is on his way up. And he's the one that was going to be retaining an attorney.
Okay. cabinet.
Okay, Judge, Mr. Spencer is here.
All right, Mr. Spencer, if you'll come on up, please. This is CR 2193. You are Jonathan Spencer, correct?
Yes, sir.
All right, and Mr. Spencer, we have you set for arraignment today on bail jumping and failure to appear on a felony, a third-degree felony, which carries a range of punishment of not less than 2 years or more than 10 years confinement in TDC. I have a note here that it's your intention to hire an attorney. Is that correct?
Yes, sir.
And who do you intend to hire? Do you know?
Scotty Allen.
Okay. And have you spoken with Mr. Allen
Oh, yesterday.
yesterday? What's the plan?
Well, actually, I tried to get my property released, but they won't let me release my property to my mother. And I have like the down for them, which is $4,000, but they won't let me release it for some reason. I don't know why. And that's what he wanted to even like start. So we're trying to see what we got to do for them to release my property.
Okay.
She have the rest.
Do you think if I give you more time, you'll be able to get that done?
Oh, yes, sir.
All right. I'll tell you what I'm going to do. I'm going to bring you back in 2 weeks on the 29th. Okay. So, you need to discuss that with the jail staff there and determine what they need you to do so that you can make arrangements to hire that attorney. Okay. So we're going to give you a notice of setting saying that we're going to come back for arraignment on April 29th. And that'll be at 9 a.m. I'll tell you what, let's set that at 1:30, Ms. Taberham, 1:30.
Yes, sir.
All right, Mr. Spencer.
Arraignment, another arraignment. Okay.
All right, we'll see you back on the 29th. You need to put a request in and talk to the jail staff so we can make sure whatever issues there are that keeps you from releasing your property that you need to hire the attorney. We need to make sure we get on top of that well in advance of the 29th. Okay.
Okay.
All right. We'll see you back on that date.
Thank you.
All right.
So do you want to make a breakout room or do you just want to?
I'm just gonna-
Hey, this is here.
Well, what I'll do is I will create a breakout room because I'll need to sit here and monitor, once they're done so I can close it down. So I'll create a breakout room and send your account and Mr. Knoll into that. And then once they're done, then I'll shut down the system.
Judge, it shouldn't take but just probably 10 minutes.
Okay.
Thank you.
Let me go ahead and set that up for y'all.
Judge, may the state be excused?
Yes, thank you, State. Appreciate you. Sorry to mute your face.
No worries, Judge. I'd be jealous too.
Good one. Look at him. And then he hung up before I could say anything.
That's what I'd have done.
Yeah, that was a good move. That was a good move. All right, here we go. All right, jail court, if you'll just accept that invitation.